The morning sun barely broke through the gray clouds as 17-year-old Maya Chen stepped off the bus 3 blocks away from the federal courthouse. Her heart was racing so fast she could hear it pounding in her ears. She pulled her grandmother's old leather briefcase closer to her chest, feeling its worn edges dig into her palms. The briefcase was at least 30 years old, scratched and faded, but it was the only thing keeping her grounded right now. Maya had woken up at 5 in the morning, unable to sleep. She'd rehearsed her opening statement at least 50 times in front of her bedroom mirror, each time trying to sound more confident than she felt. Her mom had made her favorite breakfast, pancakes with fresh strawberries, but Maya could barely eat 2 bites. The knot in her stomach was too tight. Now standing on the courthouse steps, Maya took a deep breath and looked up at the massive building. Tall marble columns stretched toward the sky, and the words "Equal Justice Under Law" were carved above the entrance. She'd visited this place twice before, just to get familiar with the layout, but today felt completely different. Today was real. Inside the courthouse, the atmosphere hit her like a wave. Everything echoed. Footsteps, voices, even the rustling of papers seemed amplified in the high-ceilinged hallways. Lawyers in expensive suits rushed past her, their leather shoes clicking against the polished floor. They carried fancy briefcases that probably cost more than Maya's entire wardrobe. Some talked on their phones in low, serious voices. Others walked in groups discussing cases in legal terms that sounded like a foreign language. Nobody looked at her. Not really. A few people glanced in her direction, but their eyes just slid right past her like she was invisible. Maya knew what they saw. A teenage girl in a department store blazer that was slightly too big for her. A kid who probably got lost looking for a school field trip. Definitely not someone who belonged in a federal courthouse about to argue a major case. Maya checked her watch. She had 45 minutes before the hearing started. She found a bench outside courtroom 4B and sat down, carefully opening her briefcase. Inside were 3 folders, each color-coded and meticulously organized. The blue folder held all her research on digital privacy laws. The red folder contained the evidence she'd spent months collecting. The green folder had her notes and the opening statement she'd written and rewritten dozens of times. She pulled out the green folder and started reading through her notes one more time, even though she practically had them memorized. Her hands were shaking slightly, making the pages tremble. She tried to steady them, but the nervousness wouldn't go away. "You okay, sweetheart?" Maya looked up to see a security guard standing nearby, a kind expression on his weathered face. He must have been in his 60s with gray hair and gentle eyes. "Yeah, I'm fine," Maya said, trying to sound more confident than she felt. "Just preparing." The guard nodded toward her briefcase. "You testifying in a case?" "Actually, I'm arguing one." The guard's eyebrows shot up in surprise. "You're a lawyer?" "Not exactly. I'm part of a youth legal initiative program. They let high school students handle certain pro bono cases under supervision." "Well, I'll be," the guard said, shaking his head with a smile. "Good for you, kid. Give him something to remember." As he walked away, Maya felt a tiny bit better. At least someone believed she could do this. She went back to her notes but couldn't concentrate. Her mind kept drifting to how she'd ended up here in the first place. 6 months ago, Maya had been sitting in her computer science class when her teacher mentioned something that caught her attention. He was talking about data collection and how tech companies tracked everything people did online. He said it casually, like it was just a fact of modern life, but something about it bothered Maya. That night, she started researching. What she found shocked her. Apps on her phone were tracking her location constantly. Websites she visited were recording every click, every scroll, every second she spent looking at something. Companies were building detailed profiles about her, her friends, everyone she knew, and selling that information to advertisers. And the worst part? It was all legal, especially for kids under 18. The more Maya researched, the angrier she got. Nobody had asked her permission. Nobody had explained what was happening in a way she could actually understand. Sure, there were privacy policies, but they were written in confusing legal language that went on for pages and pages. Her mom was a nurse and her dad worked in construction. They didn't understand this stuff either. Nobody did. That was the whole point. Maya had discovered that current privacy laws were written back in the 1980s and 1990s, before smartphones, before social media, before any of this technology even existed. The laws were completely outdated, and kids were suffering because of it. She brought her research to her civics teacher, Mr. Patterson, who was also the advisor for the youth legal program at her school. He was impressed, more than impressed actually. He suggested Maya apply to take on a real case through the program. Maya never imagined they'd actually accept her proposal, but they did. And now here she was about to walk into a federal courtroom to argue that current digital privacy laws violated the constitutional rights of minors. The hallway was getting more crowded now. Maya watched as more lawyers arrived, most of them looking relaxed and confident. A group of 5 attorneys walked past her, all wearing matching navy suits. They were laughing about something, completely at ease. Maya recognized them from the photos she'd seen online. They were the opposing counsel, the legal team representing the tech companies Maya was suing. One of them, a tall man with perfectly styled silver hair, glanced at Maya sitting on the bench. For a second, their eyes met. Then he looked away, dismissing her entirely, and continued talking to his colleagues. They walked right into courtroom 4B like they owned the place. Maya's stomach dropped. Those were some of the most expensive lawyers in the country. They worked for one of the biggest law firms in the state. They probably had entire teams of researchers and assistants helping them. And here she was, a 17-year-old girl with a borrowed briefcase and a hope that justice actually meant something. 20 minutes until the hearing. Maya stood up and walked to the restroom, needing a moment alone. She stared at herself in the mirror, barely recognizing the person looking back at her. She'd pulled her long black hair into a neat bun, the way her grandmother had taught her. Her blazer was pressed and clean, even if it didn't fit perfectly. She looked professional. She looked prepared. But inside, she was terrified. "You can do this," she whispered to her reflection. "You've done the work. You know the law. You know the facts. You can do this." A woman in an elegant gray suit walked in, talking on her phone about depositions and discovery deadlines. She gave Maya a brief, polite smile before disappearing into a stall, never breaking her phone conversation. Maya washed her hands, dried them carefully, and walked back out into the hallway. 10 minutes now. Maya returned to her bench and pulled out a folder one more time. Inside was a photo she'd printed out. It showed her grandmother, her Nana Way, standing in front of this very same courthouse almost 50 years ago. Nana Way had been a paralegal back then, working to support her family after immigrating from Taiwan. She'd never gone to law school, could never afford it, but she'd spent her entire career helping lawyers prepare cases. She'd told Maya stories about justice, about standing up for what was right even when it seemed impossible. Nana Way had given Maya this briefcase 2 years ago, just before she passed away. "This carried a lot of important papers," she'd said, her voice weak but her eyes still sharp. "Maybe someday you'll put something even more important inside it." Maya touched the photo gently, then tucked it back into the folder. She would make Nana Way proud today. She had to. The door to courtroom 4B opened and a clerk stepped out. "The court will be in session in 5 minutes. All parties should enter now. This was it." Maya stood up, straightened her blazer, and picked up her briefcase. Her legs felt shaky, but she forced them to move. She walked through the doorway and into the courtroom. The space was smaller than she'd expected, but somehow more intimidating. Dark wood paneling covered the walls. The judge's bench sat elevated at the front, empty for now but imposing. 2 tables faced the bench, one for each side. The 5 corporate lawyers were already seated at the right table, spreading out papers and whispering to each other. They had so many documents that they covered almost the entire table surface. Maya walked to the left table. It looked empty and sad compared to the opposition. She set down her briefcase and pulled out her 3 folders, arranging them neatly in front of her. One of the corporate lawyers glanced over and she caught the smirk on his face. He leaned over to whisper something to his colleague and they both smiled. Maya felt her face get hot, but she kept her expression neutral. She wouldn't give them the satisfaction of seeing her rattled. People started filing into the gallery behind her. Reporters, she guessed, based on their notepads and recording devices. A few looked curious about the case. Most looked bored, like this was just another day at the courthouse. None of them seemed to notice or care that a teenager was sitting at the plaintiff's table. "All rise." Everyone stood as the judge entered from a door behind the bench. Judge Richard Holbrook was exactly what Maya had expected from the photo she'd seen. Mid-60s with gray hair and a stern face that looked like it rarely smiled. He wore the traditional black robe and carried himself with the confidence of someone who'd been doing this for decades. The judge sat down, and everyone else followed. He picked up a paper from his desk and looked at it with an expression that Maya could only describe as annoyed. His eyes scanned the page, then he looked up and around the courtroom. When his gaze landed on Maya, sitting alone at the plaintiff's table, his eyebrows drew together in confusion. He looked back down at his paper, then back up at Maya. The confusion turned into something else. Disbelief, maybe, or irritation. Is counsel for the plaintiff present? Judge Holbrook's voice was deep and carried easily through the quiet courtroom. Maya stood up, her heart hammering. Yes, Your Honor, I'm here. The judge stared at her for a long moment. Several people in the gallery shifted in their seats, sensing something unusual was happening. One of the corporate lawyers coughed, clearly trying to hide a laugh. Judge Holbrook set down his paper slowly. You're the attorney of record? Yes, Your Honor. My name is Maya Chen, and I'm representing the plaintiffs through the Youth Legal Initiative program. The judge's expression didn't change, but Maya could see something flicker in his eyes. He picked up another paper, studied it, then set it down with a sigh that was loud enough for the whole courtroom to hear. I see, he said, and those two words carried a weight of skepticism that made Maya's stomach turn. Well then, let's get started, shall we? The way he said it, the tone in his voice told Maya everything she needed to know. Judge Richard Holbrook didn't take her seriously. He didn't think she belonged here, and he clearly believed this was going to be a complete waste of his time. Maya sat back down, her hands gripping the edge of the table. She could feel eyes on her from every direction. The reporters were suddenly more interested, probably sensing a story. The corporate lawyers were relaxed, practically lounging in their chairs, confident this would be over quickly. But Maya had come too far to back down now. She'd spent 6 months preparing for this moment. She'd worked after school and on weekends, sacrificing time with friends and sleep to build this case. She'd interviewed witnesses, filed Freedom of Information requests, researched hundreds of legal precedents, and written a brief that she believed in with every fiber of her being. Judge Holbrook might not respect her yet. The opposing counsel might think she was a joke. The reporters might see her as just a human interest story that would be forgotten by tomorrow. But Maya knew something they didn't. She knew the law was on her side. She knew the facts supported her argument. And she knew that sometimes the most powerful changes in history came from the people nobody expected. She opened her green folder and looked at the first page of her notes. Her hands had stopped shaking. The fear was still there, humming under her skin, but it was joined by something stronger now: determination. The judge was shuffling papers on his bench, clearly preparing to begin. The court reporter sat ready at her machine. The clerk stood by, waiting for instructions. Maya took one deep breath, held it for a moment, then slowly let it out. It was time to show them what she could do. Judge Holbrook cleared his throat and looked down at the documents in front of him, with the kind of expression someone might have when they found gum stuck to their shoe. He adjusted his reading glasses and glanced at Maya one more time before speaking. Before we begin, he said, his voice carrying that particular tone adults use when they're talking to children they think are wasting their time. I want to make sure we're all clear on courtroom procedure. This is federal court, not a mock trial competition. Maya felt her cheeks burn, but she kept her face neutral. I understand, Your Honor. Do you? The judge leaned back in his chair, studying her. Because I've been practicing law since before you were born, and I've seen a lot of well-intentioned young people come through these doors thinking they understand how the system works. Usually they're here to observe, not to argue. One of the corporate lawyers, a woman with perfectly styled blonde hair and a designer suit, covered her mouth to hide a smile. Her colleague next to her wasn't even trying to hide his amusement. He was openly grinning, shaking his head slightly as if he couldn't believe what he was witnessing. Your Honor, I've prepared thoroughly for this case, Maya said, trying to keep her voice steady. I've reviewed all the relevant statutes and precedents. Have you now? Judge Holbrook picked up a thick document from his desk and held it up. This is the plaintiff's brief, submitted under your name. Did you actually write this yourself? Or did your supervising attorney do the heavy lifting while you took credit? The question hit Maya like a slap. She felt anger rising in her chest, hot and sharp. She wanted to snap back at him, to tell him exactly how many late nights she'd spent researching cases and drafting arguments, how many times she'd rewritten entire sections because they weren't good enough, how her supervising attorney, Mr. Patterson, had only reviewed her work and offered suggestions, but every single word in that brief was hers. But she couldn't let her anger show. "Not here, not now." "I wrote every word of that brief myself, Your Honor," Maya said, her voice quiet but firm. "Mr. Patterson supervised and provided guidance, but the research, analysis, and writing are all mine." "Mm-hmm." The judge set the brief down and made a note on his pad. The sound of his pen scratching against paper seemed incredibly loud in the quiet courtroom. "Well, let's see what you've got then. This should be interesting." The way he said the word interesting made it clear he expected anything but. He expected boring. "Amateur. A waste of everyone's time." "Counselor," Judge Holbrook said, managing to make even that word sound dismissive. "You may present your opening statement, and please try to keep it relevant to actual law. This isn't a high school debate club where you can just appeal to emotions and feelings." Maya stood up, her legs steadier than she'd expected. She picked up her notes, walked to the center of the courtroom, and faced the judge. Behind her, she could hear someone in the gallery shifting, probably a reporter getting ready to take notes on what they assumed would be a train wreck. "Your Honor," Maya began, "this case is about the fundamental right to privacy, specifically as it applies to minors in the digital age. The defendants, a coalition of major technology companies, have created a systematic infrastructure designed to collect, analyze, and monetize the personal data of millions of teenagers without their informed consent." "Objection." "Your Honor." The lead corporate attorney stood up smoothly. He was the tall man with silver hair who'd walked past Maya in the hallway. "Counsel is mischaracterizing standard industry practices as some kind of conspiracy." "Sustained," Judge Holbrook said immediately, barely looking up. "Ms. Chen, stick to facts, not dramatic characterizations." Maya took a breath. She'd expected interruptions, but not this quickly. "Your Honor, I am stating facts. The defendant's own user agreements, which I've submitted as evidence, clearly show—" "We'll get to the evidence when I say we get to the evidence," the judge interrupted. "Right now, I want to understand your legal theory. What specific laws do you claim are being violated?" "The current digital privacy framework, Your Honor, was established primarily by laws written in 1986 and 1998, the Electronic Communications Privacy Act and the Children's Online Privacy Protection Act were groundbreaking for their time, but they fail to address the realities of modern technology." Judge Holbrook waved his hand dismissively. "So your argument is that the laws are old? Laws don't become invalid just because they have some years on them. The Constitution was written in 1787, but it still applies today." A few people in the gallery chuckled at that. Maya felt her face getting hot again, but she pushed forward. "I'm not arguing that old laws are automatically invalid, Your Honor. I'm arguing that these specific laws were written for a different technological landscape and now create a loophole that allows companies to exploit minors in ways the original legislators never imagined or intended." "Exploit is a strong word," the judge said, looking at her over his glasses. "These companies provide free services that millions of people, including teenagers, use voluntarily every day. Nobody is forcing anyone to use social media or download apps. With respect, Your Honor, that's not entirely accurate. In today's world, these platforms aren't truly optional. Schools require students to use certain apps for homework. Colleges expect applicants to have social media presence. Employers look at online profiles, and teenagers, whose brains are still developing, are being asked to make complex decisions about data privacy that even most adults don't understand." The corporate attorney stood up again. "Your Honor, if we're going to listen to amateur neuroscience lectures, perhaps we should be in a classroom instead of a courtroom." The gallery laughed at that one. Even the court reporter cracked a smile. Judge Holbrook didn't laugh, but Maya could see the corner of his mouth twitch. "Ms. Chen," the judge said, "do you have any actual legal credentials in neuroscience? Or are you just repeating something you read on the internet?" Maya felt like the walls were closing in. Every word she said was being twisted, dismissed, or mocked. The corporate lawyers looked completely relaxed, like they were watching an entertaining show rather than a serious legal proceeding. One of them was actually checking his phone under the table. "Your Honor, I don't have credentials in neuroscience, but I've submitted testimony from Dr. Rachel Kim, a neuroscientist who specializes in adolescent brain development. Her expert opinion is part of the evidence packet. We'll see if that testimony is even admissible," Judge Holbrook said. "Continue." Maya looked down at her notes, trying to find her place. Her carefully prepared opening statement was falling apart. She'd planned to build a logical progression, to lead the judge through her argument step by step. But with all these interruptions, she was losing the thread. Your Honor, the core issue is consent. Current laws require parental consent for children under 13, but nothing meaningful for teenagers 13 to 17. The companies claim that clicking "I agree" on a terms of service document constitutes informed consent, and doesn't it? The judge interrupted. People agree to terms of service all the time. That's how contracts work, Ms. Chen. Even a first-year law student knows that. The implication was clear. He was saying she didn't even have the knowledge of a first-year law student. Maya gripped her notes tighter, feeling her fingernails dig into the paper. Informed consent requires understanding. Your Honor, these terms of service documents are deliberately written in complex legal language. The average reading level required to understand them is college level, sometimes graduate level. We're asking 13-year-olds to comprehend and agree to 50-page legal documents that most adults can't understand. That's not the court's problem, Judge Holbrook said flatly. If people don't read contracts before signing them, that's on them. We don't invalidate contracts just because someone didn't bother to read the fine print. But, Your Honor, these aren't standard contracts. These are. Are you arguing that teenagers are incompetent to enter into any agreements? The judge asked. Because that opens up a whole different can of worms. Should we invalidate every contract a 17-year-old signs? Can they not buy a car or get a job? Maya felt trapped. Every argument she made was being turned against her. The corporate lawyers were loving this. She could see them exchanging satisfied looks, probably already planning their victory celebration. I'm arguing that there's a difference between a teenager understanding they're trading money for a car and a teenager understanding that an app is tracking their location 24 hours a day, analyzing their private messages, building psychological profiles, and selling that information to data brokers who— Objection. The silver-haired lawyer was on his feet again. Your Honor, this is pure speculation and fear-mongering. Our clients operate in full compliance with all existing privacy laws, which is exactly my point, Maya said, turning to face him directly. The existing laws are inadequate. Enough, Judge Holbrook said sharply. Ms. Chen, face the bench when you're speaking. And the corporate counsel is right. You can't come into my courtroom and ask me to rewrite laws just because you don't like them. That's what the legislature is for. Maya turned back to the judge, her heart sinking. This was going even worse than she'd feared. She could see it in his eyes. He'd already made up his mind. He thought she was a kid playing lawyer, wasting the court's time with idealistic nonsense that had no legal basis. Your Honor, I'm not asking you to rewrite laws. I'm asking you to recognize that the current application of these laws violates constitutional protections, specifically the Fourth Amendment right to privacy and the 14th Amendment's due process clause. The Fourth Amendment? The judge actually laughed at that, a short, sharp bark of disbelief. That protects against unreasonable government searches, not private companies collecting data that users voluntarily provide. The Supreme Court has extended Fourth Amendment protections to include a reasonable expectation of privacy, even in interactions with private entities when those interactions are functionally unavoidable, Maya said, her voice stronger now despite everything. In Riley v. California, the court recognized that cell phones contain intimate details of our lives and deserve heightened privacy protection. For the first time, Judge Holbrook paused. He looked at her with something that might have been the tiniest hint of interest. You're citing Riley. That was a search and seizure case involving law enforcement, not corporations. Yes, Your Honor, but the principle applies. The court recognized that digital information is qualitatively different from physical information. It's more intimate, more revealing, and requires stronger protection. If that's true for adult criminals, it's even more true for teenage children who haven't committed any crime. The judge was quiet for a moment, actually thinking about what she'd said. But then he shook his head. That's a stretch, Ms. Chen. A creative argument, I'll give you that much, but ultimately unconvincing. Maya felt her hope deflating. She'd played one of her best cards, and it had barely made a dent. The silver-haired corporate attorney stood up again, sensing an opportunity. Your Honor, if I may, this entire case appears to be based on the plaintiff's personal feelings about technology rather than any actual legal violations. With all due respect to Ms. Chen's enthusiasm, this is exactly the kind of frivolous lawsuit that wastes judicial resources. I'm inclined to agree, Judge Holbrook said, and Maya's stomach dropped. Ms. Chen, I appreciate that you care about this issue. I really do. It's admirable that young people want to engage with the legal system. But caring about something doesn't make it a viable legal case. Your Honor, please, if you'll just look at the evidence I've submitted. I've seen enough evidence for now, the judge said. What I need is a coherent legal theory, and I'm not hearing one. You're throwing out constitutional amendments and Supreme Court cases, but you're not connecting the dots in a way that makes legal sense. Maya felt desperate now. She was losing. She could feel the case slipping away before she'd even gotten to present half her arguments. The reporters in the gallery were starting to look bored again. One was already packing up his notebook, clearly deciding this wasn't worth covering. Your Honor, just give me a chance to present my evidence. I have internal documents from these companies that show— What kind of internal documents? The judge asked skeptically. Communications between executives discussing strategies for maximizing data collection from teenage users. Deliberate design choices made to manipulate adolescent psychology. Research they conducted on how to bypass critical thinking in young people. The corporate lawyers suddenly looked less relaxed. The silver-haired man stood up quickly. Your Honor, we were not made aware of any such documents in discovery. If the plaintiff has obtained proprietary corporate communications through improper channels, I obtained them through a Freedom of Information Act request, Maya said firmly. They were included in the evidence packet I submitted 2 weeks ago. Judge Holbrook frowned and started shuffling through papers on his desk. He pulled out a thick folder and opened it, scanning the contents. The courtroom was completely silent except for the rustling of pages. Maya held her breath. This was it. If the judge actually looked at those documents, actually read what she'd found, he might understand. He might see that this wasn't just some teenager with hurt feelings. This was real. This was important. The judge read for what felt like an eternity but was probably only 2 minutes. His expression was unreadable. Finally, he looked up, first at Maya, then at the corporate lawyers, then back at Maya. Where exactly did you get these documents, Ms. Chen? I filed a FOA request with the Federal Trade Commission, Your Honor. These companies were investigated 3 years ago for potential privacy violations. The investigation was closed without charges, but the documents collected during the investigation became public record. I requested them and the FTC provided them. The corporate lawyers were whispering urgently to each other now. The silver-haired man looked genuinely concerned for the first time since the hearing began. Judge Holbrook continued reading, his frown deepening. And you filed this request yourself? A high school student? Yes, Your Honor. It's not illegal for a minor to file a FOIA request. I followed all the proper procedures. The judge made a sound that might have been a or might have been something else. He kept reading. Maya could see his eyes moving across the pages, taking in the information she'd spent weeks analyzing and organizing. When he finally looked up again, something in his expression had changed. Not completely, but slightly. The outright dismissiveness was gone, replaced by something more complicated. Curiosity, maybe, or confusion. He looked at Maya like he was seeing her for the first time, actually seeing her, instead of just seeing a kid who didn't belong in his courtroom. These documents, he said slowly, suggest that the defendants conducted psychological research on teenage users without their knowledge or consent. Is that your interpretation? Yes, Your Honor, and not just research. They used that research to design features specifically meant to maximize engagement by exploiting developmental vulnerabilities in adolescent brains. The corporate lawyer jumped up. Your Honor, that's an outrageous mischaracterization of standard user experience research. Every company studies how users interact with their products. I'm not talking about standard research, Maya said, her confidence growing. I'm talking about research specifically targeting the fact that teenage brains are more susceptible to certain stimuli. Research on how to trigger reward responses, how to create compulsive usage patterns, how to maximize data extraction before users realize what's happening. Judge Holbrook held up his hand, silencing everyone. He looked at the corporate lawyers. Counselor, are you familiar with these documents? The silver-haired lawyer shifted uncomfortably. Your Honor, we'll need time to review whatever the plaintiff has submitted. We can't be expected to respond to surprise evidence. These documents were submitted 2 weeks ago, Maya said. They're part of the official evidence packet. We receive hundreds of pages of documents in cases like this, the lawyer said defensively. We can't be expected to memorize every single page. Judge Holbrook's expression hardened slightly. You should at least be familiar with documents that directly concern your client's business practices. But fine, we'll take a 15-minute recess to let you review the materials in question. He banged his gavel. Court is in recess. As everyone stood, Maya felt like she could finally breathe. It wasn't much. It wasn't a victory, but it was something. The judge had actually looked at her evidence. He'd actually asked questions about it. And the corporate lawyers for just a moment had looked worried. Maya gathered her papers with shaking hands. Across the aisle, the corporate legal team was huddled together, speaking in urgent whispers and frantically paging through the evidence folder. They weren't laughing anymore. Maybe, just maybe, she had a chance after all. Maya stepped out into the hallway during the recess, her legs feeling like they might give out at any moment. She found the same bench she'd sat on earlier and collapsed onto it, her briefcase landing beside her with a thud. Her hands were still trembling and she pressed them together in her lap, trying to calm down. That had been brutal. Worse than she'd imagined. She'd prepared for tough questions, sure, but she hadn't prepared for the judge to treat her like a child playing dress-up. Every word out of her mouth had been questioned, dismissed, or mocked. And those lawyers, they'd barely even tried to argue their case. They just sat back and watched the judge do their work for them. "Hey, you're doing great in there." Maya looked up to see a young woman, maybe mid-20s, standing nearby with a notebook. She had curly brown hair pulled back in a ponytail and wore jeans with a blazer. A press badge hung around her neck. "Thanks," Maya said quietly, though she didn't feel like she was doing great at all. "I'm Riley. I write for the legal blog Circuit Break. Mind if I ask you a few questions?" "I probably shouldn't talk about the case," Maya said, remembering what Mr. Patterson had told her about speaking to press. "That's fine. I'm just curious about you. How'd you get involved in this? Not many 17-year-olds file federal lawsuits." Maya managed a small smile. "I got angry about something and decided to do something about it instead of just complaining online." Riley laughed. "Well, you've definitely done that. Those corporate lawyers in there look like they just swallowed lemons. I've covered cases with their firm before. They usually walk in expecting easy wins. This isn't going how they planned." "Really?" Maya felt a tiny spark of hope. "Because from where I'm sitting, it feels like I'm getting destroyed in there." "Are you kidding? You cited Riley vs. California. That was brilliant. And those documents you submitted?" I saw the lead counsel's face when the judge started reading them. That wasn't the face of someone who's winning. Before Maya could respond, Riley's phone buzzed. She glanced at it and grimaced. "I've got to take this. But seriously, keep doing what you're doing. You're making them nervous, and that's half the battle." As Riley walked away to answer her call, Maya felt slightly better. Maybe she wasn't completely failing. Maybe she was making more of an impact than she realized. She pulled out her phone and saw 3 text messages from her mom. "How's it going? You okay? Call me when you can." Maya typed back a quick, "Still going, I'm okay, love you," and put her phone away. She didn't want to talk to anyone right now. She needed to focus. Maya opened her briefcase and pulled out the red folder, the one with her key evidence. She'd been planning to introduce this material later, but maybe she needed to play her strong cards earlier. Stop being so careful. Stop holding back. Inside the folder was a printed email chain between executives at one of the defendant companies. Maya had read it so many times she practically had it memorized. But she read it again anyway. The emails discussed something called Project Butterfly. The name sounded innocent enough, but what it described was anything but. The company had hired a team of psychologists to study how teenage brains responded to different app features. They'd specifically focused on the prefrontal cortex, the part of the brain responsible for decision-making and impulse control, which doesn't fully develop until the mid-20s. The psychologist had identified specific design elements that could override rational decision-making in teenagers. Bright colors, notification sounds, artificial scarcity like, "Only 3 of your friends have seen this." Social pressure elements like everyone in your class is using this feature. But the part that really got Maya, the part that made her blood boil every time she read it, was one specific email from a vice president. It said, "The key is to establish habitual usage before users develop critical thinking skills. Once the behavior pattern is set, it's much harder to break even when they're old enough to recognize the manipulation." They knew exactly what they were doing. They were deliberately targeting kids. deliberately exploiting the fact that teenage brains were still developing, deliberately creating addictive patterns before those kids were old enough to recognize what was happening to them. And it was all legal. That was the crazy part. Nothing in current privacy laws specifically prohibited this kind of psychological manipulation of minors. Maya also had testimony from Dr. Rachel Kim, the neuroscientist Riley had mentioned earlier. Dr. Kim had reviewed the Project Butterfly materials and provided an expert opinion. She'd explained in clear terms how these design choices specifically targeted vulnerabilities in adolescent brain development. Even better, Maya had managed to track down someone who'd actually worked on Project Butterfly. His name was Daniel Torres, and he'd been a junior data scientist at the company 3 years ago. He'd left the company after Project Butterfly launched, disturbed by what he'd helped create. It had taken Maya 2 months to find him, and another month to convince him to provide testimony. Daniel's statement was devastating. He described how the team had celebrated when their designs increased teen engagement metrics by 40%. How they'd deliberately hidden the data collection features in complex menu settings that teenagers would never find. How they'd A/B tested different privacy policies to find the ones that looked protective but actually gave the company maximum access to user data. Maya had all of this.
Real evidence.
Real testimony. Real proof that these companies weren't just accidentally collecting data from teenagers. They were hunting them. Court will resume in 5 minutes. The clerk's voice echoed down the hallway. Maya closed the folder and put it back in her briefcase. She stood up, straightened her blazer, and took several deep breaths. This was it. Time to stop playing defense and go on the attack. When she walked back into the courtroom, the atmosphere had changed. The corporate lawyers were still at their table, but they weren't relaxed anymore. They were sitting upright, alert, with papers spread everywhere. The silver-haired lead counsel was on his phone, speaking in a low, urgent voice. When he saw Maya enter, he quickly ended the call. Good. Let them be worried. All rise. Judge Holbrook entered and everyone stood. When he sat down, Maya noticed he'd brought the evidence folder with him to the bench. He'd been reading it during the recess. Actually reading it will continue, the judge said. His tone was different now. Not friendly exactly, but less dismissive. More businesslike. Ms. Chen, you were presenting your opening arguments. You may continue, but let's skip the broad constitutional theories for now. I want to hear about these specific documents you've submitted. Maya stood up, and this time she left her notes on the table. She didn't need them for this part, Your Honor. I'd like to direct your attention to Exhibit 14A through 14G. These are internal emails from the Defendant Tech Connect discussing something called Project Butterfly. The corporate lawyers immediately started whispering to each other. The silver-haired man stood up. Your Honor, before we proceed, I'd like to note that these emails may contain proprietary business information. They were obtained through a legal FOIA request, Judge Holbrook interrupted. If they were meant to be confidential, perhaps your clients shouldn't have shared them with federal investigators. Continue, Ms. Chen. Maya felt a rush of satisfaction. The judge had just shut down the opposition. That had never happened before. Project Butterfly was a research initiative launched 3 years ago, Maya explained. The stated goal was to improve user experience for teenage users. But the actual goal, as shown in these emails, was to exploit specific vulnerabilities in adolescent brain development to maximize data collection and user engagement. That's an inflammatory characterization, the corporate lawyer said, but he didn't stand up this time. Studying user behavior is standard practice. May I approach, Your Honor? Maya asked. Judge Holbrook nodded. Maya walked to the bench and handed him a specific document. This is an email from Robert Chen, who was Vice President of User Engagement at the time. I'd like to read the relevant section if I may. Go ahead. Maya had the words memorized, but she read from the paper anyway. Quote, the key is to establish habitual usage before users develop critical thinking skills. Once the behavior pattern is set, it's much harder to break, even when they're old enough to recognize the manipulation. End quote. The courtroom went very quiet. Maya could hear someone in the gallery shift in their seat. A pen dropping would have sounded like thunder. Judge Holbrook read the email himself, his eyes moving across the page slowly. When he looked up, his expression was unreadable. What exactly was this person's role in the company? He was in charge of designing features to increase how much time users spent on the platform. Your Honor. And according to other emails in the chain, he reported directly to the CEO. The judge looked at the corporate lawyers. Counselor, did your client's executives really write this? The silver-haired lawyer stood up, and for the first time he looked uncomfortable. Your Honor, taken out of context, certain business communications can sound more problematic than they actually are. What Mr. Chen was referring to was simply the goal of making the platform intuitive enough that it becomes a natural part of users' daily routines. That's not what it says, Maya interjected. It specifically mentions, before users develop critical thinking skills and manipulation. Those aren't words you use when you're just making something intuitive. Judge Holbrook held up his hand. I can read what it says, Ms. Chen. The question is what it means. Counselor, you'll have an opportunity to explain this during your presentation. For now, I want to hear the rest of what Ms. Chen has to say. Maya felt a surge of confidence. The judge was listening. Really listening. Your Honor, I also have expert testimony from Dr. Rachel Kim, a neuroscientist specializing in adolescent brain development. She reviewed the Project Butterfly materials and concluded that they represent a deliberate exploitation of known vulnerabilities in teenage neurology. Maya walked back to her table and pulled out another document. Dr. Kim specifically notes that the prefrontal cortex, which controls impulse regulation and decision-making, isn't fully developed until the mid-20s. The defendants knew this. They researched it, and then they designed their platforms specifically to bypass those underdeveloped regulatory systems. Your Honor, this is turning into a neuroscience lecture, not a legal argument, the corporate lawyer objected. Actually, I think it's relevant, Judge Holbrook said, surprising everyone. If the plaintiff can show that these companies deliberately targeted minors in ways that minors couldn't reasonably protect themselves from, that could have legal implications. Continue, Ms. Chen. Maya's heart was racing, but in a good way now. She was getting through to him. More importantly, Your Honor, I have testimony from someone who actually worked on Project Butterfly. Daniel Torres was a data scientist at Tech Connect from 2021 to 2022. He was part of the team that implemented these designs. She pulled out another document. Mr. Torres describes how the team deliberately hid data collection settings in complex menus that teenage users would never find. How they tested different privacy policies to find ones that looked protective but actually gave maximum data access. How they celebrated when their manipulative designs increased teenage engagement by 40%. The corporate lawyers were frantically passing notes to each other now. This was clearly information they hadn't expected. Maybe they hadn't read the full evidence packet as carefully as they should have. Your Honor, I object to hearsay testimony from a disgruntled former employee, the silver-haired lawyer said. Mr. Torres has provided a sworn affidavit, Maya countered. He's willing to testify in person if needed. This isn't hearsay. It's eyewitness testimony. Judge Holbrook was writing notes, his pen moving quickly across his legal pad. Ms. Chen, let me ask you something. Even if everything you're saying is true, even if these companies deliberately designed their platforms to be manipulative, how is that illegal? Advertising has been manipulating people for decades. Companies study psychology to sell products all the time. What law are they actually breaking? This was the question Maya had been waiting for. This was the heart of her entire case, Your Honor. They're not breaking existing laws. That's the problem.
The laws are inadequate.
But what they're doing violates the constitutional principles those laws are supposed to protect. She walked to the center of the courtroom, speaking clearly and confidently now. All her preparation, all those late nights researching cases and writing arguments, it all came down to this moment. In 1918, the Supreme Court struck down federal child labor laws in Hammer v. Dagenhart. They said regulating child labor was a state issue, not a federal one. But we as a society eventually recognized that was wrong. We recognized that children needed federal protection because they lacked the power and understanding to protect themselves in an industrial economy. Maya could see she had everyone's attention now. Even the corporate lawyers had stopped whispering and were listening. Your Honor, we're facing the exact same situation today, just in a different context. In 1918, it was factories. In 2025, it's data platforms. 10-year-olds couldn't negotiate fair wages in factories because they didn't understand the economic system they were in. 17-year-olds can't negotiate fair data practices with billion-dollar tech corporations because they don't understand the digital ecosystem they're in. Judge Holbrook had stopped writing. He was just listening, his full attention on Maya. Just like factory owners in 1918 knew they were exploiting child labor, and did it anyway because it was profitable and legal, these tech companies know they're exploiting teenage psychology and they do it anyway because it's profitable and legal. The law hasn't caught up to the technology, and an entire generation is being exploited in that gap. The courtroom was completely silent. Maya could hear her own heartbeat pounding in her ears. The Fourth Amendment guarantees a right to privacy. The 14th Amendment guarantees due process. When companies deliberately manipulate children into giving up their privacy, before those children are neurologically capable of understanding what they're giving up, that violates the spirit of those constitutional protections, even if it doesn't technically violate the letter of outdated statutes. Maya walked back to her table, her legs surprisingly steady now. Your Honor, I'm not asking you to rewrite laws. I'm asking you to recognize that applying outdated laws to modern technology, in a way that allows the systematic exploitation of minors, is unconstitutional. I'm asking you to protect children the way the Constitution intended them to be protected. She sat down. For a long moment, nobody moved. Nobody spoke. Then Judge Holbrook removed his glasses and rubbed his eyes. When he looked up, he wasn't looking at Maya like she was a kid anymore. He was looking at her like she was a lawyer. A real lawyer who just made a real argument. Ms. Chen, he said quietly, that was quite an argument. The silver-haired corporate lawyer stood up quickly. Your Honor, with all due respect, emotional appeals about protecting children don't change the fact that— I'm not talking to you right now, counselor, Judge Holbrook said sharply. Sit down. The lawyer sat down, looking stunned. The judge looked at Maya for a long moment, then down at all the evidence spread across his bench. I'm going to need time to review this material thoroughly. This case is more complex than I initially thought. He made a few more notes, then looked up at both legal teams. We'll take a 1-hour recess. When we return, I want to hear from the defense. And, counselor, he looked directly at the silver-haired lawyer, I suggest you come back prepared to address these specific allegations rather than just making general objections. He banged his gavel. Court is in recess.